Good night, everyone. This is U.S. Immigration Attorney Sharifa Tharpe. So I have a good topic to talk about tonight, and it is what is taking so long when it comes to consular processing. Why does it take so long? I'm going to explain why. But first of all, I want to let you know that I'm here to answer your U.S. immigration related questions. So go ahead, put your questions in the comments. I will still prioritize your questions, but in between the questions, I am going to talk about that. I'm going to explain why the immigration process, when it comes on to consular processing, the consular processing is where your relative, your immigrant relative, is outside of the United States and waiting to get an immigrant visa to come to become a permanent resident. Why is that taking so long? And a part of that, of course, is going to explain some of those processing times and the consular process. Now, why does it take so long? Now, it really depends the length of time that it takes. So I'm on here on a 5-year visa. So now, what type of 5-year visa are you here on, Kwabe? Her Excellence, thanks so much for the rose. Her Excellency, thanks for the rose. Now, go ahead, Kwabe, if you want to elaborate a little bit more for, what type of 5-year green card you're on. Now, what takes so long? Now, processing times really depend on what process you're going through, who's applying for you. When it comes to consular processing, you're placed in different categories. And depending on the category that you're in, then it's going to determine how long your process is going to take. And there are ways to figure out how long that your process will be. How could I help my sis-in-law and brother-in-law if they are dreamers? So Justice Fuerte, it's really going to depend on, you can't sponsor a sister-in-law and you can't sponsor a brother-in-law, unfortunately. They would have to qualify through some means. So they would have to first qualify through a family member who is going to either be, in this case, a spouse, a U.S. citizen, or legal permanent resident spouse or parent, or a citizen son or daughter who's 21 and up. They could also adjust that, not adjust status, but apply for permanent residence and try to fix their status through an employer. But they still have to, even through an employer, the way that they would have to fix their status is also by having a U.S. citizen or legal permanent resident spouse or parent to allow them to be able to adjust, be able to fix that overstay. Now, the particular solution to their issue is really going to depend on their circumstances. And so that's definitely where the consultation is going to come in. So Kwabe, a B1, B2. So when you're on a B1, B2, having it for 5 years does not mean that you get to stay in the United States for 5 years. That is very important for you to understand. When you come into the country, you're either going to have a permitted period of time, usually up to 6 months, not definitely doesn't go on for years, up to 6 months where you can stay and visit the United States. And you are going to see the particular time, specific time that the officer gave you stamped in your passport, or if you didn't get a stamp in your passport, you are going to find that time on your I-94. So very important that you check that date and, don't stay for those 5 years. It just means for the next 5 years, you could be back and forth on that 5-year visa, but you still have to stay within the permitted time and leave within that permitted time. So how could I help my sis? I answered that. My dad lives in the USA for 37 years. He was married, but he got divorced. And then I didn't see the rest of it. So how old does a U.S. citizen have to be before you sponsor their parents? So sweet, honest, it is the U.S. citizen has to be 21 or up to be able to sponsor their parents. Hi there, Raisa, it's nice to see you. A friend of mine is doing nanny work. Can her employers help her out if she's undocumented? So if she is doing and she is a nanny, she's undocumented. If they are looking to apply for her as an employee, there may be a way, but it's really going to depend on whether they're willing to go through that process, what kind of position they'll be willing to give her and her qualifications, and how they can best state that she's in a unique position to be able to work in the particular job that they want to give her. So in her case, you definitely need a consultation to evaluate all those options. So his wife didn't do the paperwork. Okay, so if he is divorced and he's been divorced for less than 2 years, Immaculate Hope, there may still be a way for him to apply on his own, but the clock is ticking. Because if he's been divorced for less than 2 years, once it hits 2 years, the 2-year mark after his divorce, he will no longer qualify to apply for permanent residence on his own. Now, keep in mind that whether he qualifies, it's going to depend on the particular circumstances in the marriage. What happened in the marriage? Was he mistreated by his wife? Certainly, with her being married, so he was in the U.S. for 37 years, and let me see, he was married. So if he was married for a large part of that period and his wife did not apply for him, that could indicate a bigger problem here, that there were some serious, severe problems in the marriage, and that's what I'd want to explore, because if there was, and he was mistreated, then he could possibly apply on his own, but he would have to be divorced for less than 2 years to qualify for this. So tell your dad to schedule a consultation and get going, because if there is a solution, and this is a solution where he could apply on his own, apply for a work permit, apply for his permanent residence while staying in the U.S., he would have to do it less than 2 years after his divorce. How long would it be before my husband can get his citizenship? So if he married you and you're a U.S. citizen, then it would be, and if he's still married to you, of course, then it would be 3 years before he can apply for U.S. citizenship. My wife did sponsor them, but they never got back to them. What further steps should we take? So Justice Fuerte, if your wife sponsored your brother-in-law and your sister-in-law, it's a 14-year process. If you're from Mexico, then that's up to 20 years. So it is an extremely long process. Now, a solution is going to depend on there is no quick and easy solution when it comes on to a U.S. citizen filing for their siblings, unfortunately. And if they're here in the United States already, it definitely would not be the best solution to fix their status, because first of all, it takes a minimum of 14 years, upwards of 20 years in some places. And even if they overstayed, even if they got to the point of being able to get an interview at the embassy, they would have to contend with the consequences of leaving the country after overstaying. Because remember, when someone overstays over 180 days in the United States, if they leave the country, they automatically have a bar of 3 years. If they overstay over a year, that turns into a 10-year bar. And so they would have to apply for a waiver. But the waiver is going to depend on the extreme hardship of a U.S. citizen or legal permanent resident spouse or parent. So it's complex stuff, and it's in order to really sift through a more precise solution for them, they would have to schedule a consultation if they really would like to figure out a way to either fix their status or obtain permanent residence. I filed my visa extension last June and still no feedback from the USCIS. What if it gets denied? So Raisa, if this is for the B2 extension, after you have filed the B2, you probably, if you don't hear anything, then you still are allowed to stay past the time, as long as you properly filed the extension and you received confirmation that you filed it. Then you could stay until you get a decision. Once you get the denial, you'll definitely have to make sure that you leave the country within the time that you're supposed to in order to avoid an overstay. And just make sure you have all the evidence to show you applied, and then and that you left after if you received a denial. What can he do? He's undocumented to Immaculate Hope, so he should schedule a consultation. If he was divorced for less than 2 years, that could offer him the ability to apply on his own if he was being mistreated by his wife. So the consultation is very important. Now, I keep mentioning the consultation. If you would like to schedule a consultation, you can go ahead, go to the link in my bio. It will take you to the website where you can fill out a contact form, or you can call the number. There are after hours receptionists right now who will take your call, take your information, and then pass it on to a scheduling coordinator to contact you tomorrow. What does prima facie mean? So initially, when you submit your VAWA application, this is the application based on mistreatment by certain U.S. relatives. When you're applying on your own, they will do a preliminary review of your application. And once they do the preliminary review, if they find that you have meet all the requirements, they will issue a prima facie letter, sort of like a pre-approval. It's not an official approval yet, but it's letting you know that right now, based on their initial review, you look as if you will meet the requirements to get VAWA. Then an officer will go back again and then review your case with a little more detail. And if they have additional questions, you'll definitely hear from them, or you will get the approval, or you'll get the denial, or the approval or decision, I should say. So the prima facie is definitely a good start, and it's a good sign for for your future eligibility for VAWA. Heather Jones, thanks for sharing the live. Do I need to leave ASAP after visa extension denial? Yes, so you would have to leave after that denial. Can you help me to get SSC? They send second time. I didn't receive my address. Is even not coming in the post office. So PB32, I would need to schedule a consultation to determine whether you qualify to receive help for your situation. And I would have to get details to determine whether I can help you. How long will it take for my father to file for me? I'm 40 years old. So if your father is a U.S. citizen, it's and you're unmarried, it's 6 to 7 years. If your father is a green card holder and you're unmarried, it's 5 to 6 years. If your father is a U.S. citizen and you're married, it's taking 12 years. Raisa, you are welcome. I want to divorce my wife, but she already filed for my daughter. Will that avoid her from coming? So it could possibly, because if you do divorce your wife, then she could withdraw the application for your daughter. So you would have to have the conversation with her, as to whether she would continue to file for her stepdaughter, or if I don't know if the daughter is her biological child as well. But if not, if the daughter does qualify as a stepchild, or it's her daughter, it's really going to depend on what your wife wants to do with the paperwork going forward, because she can't necessarily be forced to file for anybody. Do I speak directly to you when scheduled consultation? Bossy Cookie, absolutely. So I do take pride in that I meet with all the clients that schedule consultation, to make sure I personally hear your issues and advise you. So now keep in mind that the information here I'm giving you is not legal advice. It's not personal legal advice. So it's general information. And so if you would like personal legal advice about your situation, you definitely need to schedule the consultation. So for example, Raisa, I know that you have applied for an extension, but keep in mind that this information is just for informational purposes. It's not information that you should necessarily act on because I'm not your attorney. And I really would not be able to provide you personal legal advice, but I can answer your general questions. And as your information is general, so are my answers. So my son, a USA citizen, can my child under 21 can join me? So I'm wondering, are you saying, can your child, your child under 21? So user 769, I am going to interpret this two ways. So Bossy Cookie, you're welcome. So one, are you asking if your son is sponsoring you, can you bring along your child who's under 21? So if your child who's under 21 has been, your child who's over 21 or over is sponsoring you, but you have a child who's under 21, you would not be able to carry a dependent as an immediate relative of a U.S. citizen. Now, if that's one, I think, one way I'm interpreting your question, but if you're asking if your son who is under 21 can sponsor you, the answer is unfortunately not. You'd have to wait until they turn 21 to be able to sponsor you. So I hope that was helpful. Raisa, I'm glad. Thanks for letting me know. So keep your questions coming and I will answer your question. So I have a question that I am going to bring to you that I'm also going to answer, and it's why does the consular process take so long for some people? It really depends on what category you're in. As the immediate relative of a U.S. citizen, so immediate relatives of U.S. citizens are the spouse of a U.S. citizen, the parent of a U.S. citizen, the parent of a U.S. citizen who's 21 and up, or the son or daughter of a U.S. citizen who is under 21 and unmarried. If you are within this category, the processing time to get permanent residence during the consular process and even adjustment of status, that's where you stay in the U.S. and apply, is much shorter. So it can range anywhere from 10 months to 24 months. Believe it or not, 24 months is still shorter than other processes. However, if you are being sponsored, if you are 21 and up, unmarried, and you're being sponsored by a U.S. citizen parent, that turns into a 6 to 7 year process. If you are unmarried, you're 21 and up, and you're being sponsored by a green card holder, that turns into a 5 to 6 year process. If you are the married son or daughter of a U.S. citizen, that turns into a 12-year process. If you are the sibling of a U.S. citizen, that turns into a minimum of 14-year process. In Mexico right now, it's going to 20 years. Now, to the other category that is shorter right now, but that may not last, is being the spouse or the child under 21 and unmarried of a green card holder. So that's another shorter category that is about 1.5 to 2 years long. Then I'm going to explain in a minute why those processing times are so long outside of being the immediate relative of a U.S. citizen. So I have TPS. My fiance is a citizen. I was brought here as a child unlawfully. Can I do the pardon or return? So if you were brought here and you were brought here without inspection, meaning you didn't come in with a visa, you didn't go through the immigration, the border and speak to an officer, at that point you would likely have to go through another process, and that's to go to your home country, but apply for a waiver, as you said, a pardon, to be able to leave the country to go. So the pardon, where a pardon or a waiver could apply is if, for example, you came in with a visa, you came in with a fraudulent visa, but you were still inspected at the border, then in that case, you could still possibly adjust status and apply for a waiver while you're adjusting status here. Otherwise, so as you can see, the solution here, Diana, the divine goddess, is going to depend on what the facts are, because that's what a lot is missing here. And so I can tell you there are the two common ways that you would have to you could get permanent residence. One is adjustment of status if you were inspected. So even though you were brought here, did you overstay a visa? Did somebody bring you in and then did you overstay? Or did you sneak across the border? For example, did you sneak across the border of Mexico, or did you come in by boat, or did you come in from Canada? Those, you'd have to answer those questions for me to determine whether you qualify for adjustment of status or whether you'd have to apply for a waiver, and that waiver would allow you to leave to attend the interview at the embassy and not face the consequences of the overstay. So schedule a consultation, Diana the Divine Goddess, because that's where you're going to get personalized legal advice. I'm from Jamaica. Do some of the laws that you're stating, does it apply to me? So freelance user, it could. I don't know what your situation is, but I am speaking in general terms. So it's possible that it could, but you'd have to speak with me. Boat and no inspection. So in the case that you came in by boat and no inspection, it's likely going to be the waiver process. So first you can stay here, apply for the waiver, and then once you are granted the waiver through your U.S. citizen spouse, then you would be able to wait for your interview, attend your interview, and then come back after the interview, all being well. So it's very important for you to get legal advice and get legal representation, because one thing I want to advise you about is you should never underestimate the waiver process. It is complex. It requires strategy, legal know-how, and a lot of coordination. And so you don't want to make any mistakes on that. You want to increase your chances of success. So you can always call, schedule a consultation. Let's confirm that this would be the right process for you, because remember, I'm not giving you personal legal advice. It's general information. And so a consultation, it would be necessary to provide you the advice you need to figure out how to go forward. My husband cheated on me as soon as he received the I-7 form. I think he assumed he was getting, let's see, I missed the other part of it. So I'm so sorry that happened, but I don't see the other part of your question. So I'm going to wait to see if you can retype your question, and then I can answer. If I get married to American citizen, how long does it take for the filing? So you could be looking at about a year and a half. Expect a year and a half process. So if I overstayed my visa, what can I do? So the solution is going to depend on your particular circumstances. How do you qualify to still, even though you overstayed? Are you the immediate relative of a U.S. citizen? If you are, that could possibly allow you to adjust status in the United States and get permanent residence. Were you the victim of a crime? Were you the victim of trafficking? Are you from a TPS country? TPS countries are those countries where you are getting temporary protected status, such as Haiti, Venezuela, Nicaragua, Honduras, Sudan. So these are some of the countries where you can actually get protection to stay in the United States. So there are so many different options, but it really depends on how you're going to qualify to stay even after overstaying. So Ranian, that's where it's very important for you to get legal advice. Schedule a consultation. You can do that by calling the number. It's plastered all over the website. So how long is the wait for marriage to U.S. citizen based in New York? So it's not usually based on the state that you're in. It is mainly based on maybe the service center that's processing your case. Service centers are scattered all over the United States and not necessarily in the state that you're living in. But you could expect about a year and a half process. And if you do know the service center that's processing your case right now, you can go and look at the service center and and you can get a more precise idea of the range of time it's going to take based on that service center. Ranian, you are welcome. So Lorenable, let's see. So my husband cheated on me as soon as he received the I-797 form. I think he assumed he was getting the 10-year. So, okay, so I see. So he is the immigrant. So I'm so sorry that happened to you, and so if that is the case, you know, it definitely would be up to you as the immigrant to determine what direction you as the petitioner to determine what direction your marriage is going to go in, and of course that is going to also affect his direction in regards to his status. So it's definitely something to think about. So keep those questions coming. I'm here to answer questions. And now tonight I'm going to talk to you about the reason these applications take so long. Unfortunately, in the immigration world, it is a process. It is a tedious process, and it can be long. And the main reason when it comes on, if you're outside of the United States and you're applying for the immigrant visa to come, so we have 2 kids. Will my husband automatically get his 10-year? So Lorenable, it really depends on what direction you're going to go in. Are you going to proceed with the permanent residence? And I don't know what he's doing on his end, but a lot of it is going to depend on his actions on his green card. It's going to depend on what actions you take. And so if you choose to stop the process, then he definitely wouldn't get it through you. I don't know if he could pursue other options. However, if you do decide to proceed with the green card application, and you have been married for more than 2 years, at the time he gets approved, he would get the 10-year. Hi there, J Hein 274. So I'm filing for divorce and I'm not going to proceed with my sponsorship. So in this case, he wouldn't get it through you. And so he would have to find another way to qualify. And if you are filing for divorce, you would not be attending his final interview. Then he would not be able to get it through you. However, I would not know what options he could be pursuing separately. I'm doing OPT 1 year. My current employer does not sponsor. What are my other options? So at Navia, it's going to depend on how else do you qualify. Do you qualify? Do you want to go back to school? Are you looking for other prospects, other employers who could possibly be interested in sponsoring you for other employment-based visas, like for example, like the H-1B, if that's something you qualify for? So that's an extremely broad question. For example, if you're here on OPT and you have a family member who can apply for you, that could be one way. If you have an employer who's willing to sponsor you and apply for you, that could be another way. Whether you get to stay here is really gonna be all up to timing though. So for example, if another employer decides to hire you, you may still have to wait it out outside of the United States because you can't extend the OPT. And so you'd have to probably wait outside of the United States while the new employer sponsors you. So it's really the process you take, the length of time it takes, who sponsors you is going to depend on, do you qualify? How do you qualify? If someone didn't receive work permit after waiting 10 months, is it normal in Potomac services? So J Hein 274, you would have to go to the Potomac Service Center, go to uscis.gov, scroll down to case processing times, and you can look up the I-765 form at the Potomac Service Center. And if 10 months is not within their range, so if they, for example, they say they're taking 5 to 9 months, that means you're outside of the processing time, and you could submit a case inquiry to figure out what's going on, why it's taking so long. However, if their processing time is say 6 to 19 months, unfortunately, you would still be within that time. How long does it take to process an I-130 petition for a child under 21 who lives outside of the U.S.? So you could expect, I would say, expect an 18-month process. How long after can you apply for citizenship after receiving a green card through spouse? So if it is you receive your green card through a U.S. citizen spouse, or you're married to a U.S. citizen, then it's 3 years. You're welcome, Lauren Abel, and good luck with everything. I've learned so much. Thank you for extending your time and educating us. Thank you so much, Bossy Cookie. I appreciate that as well, and I'll keep showing up. Hi there, can you apply for citizenship while you're waiting for a final 10-year green card? Yes, it is a possibility. Now, in order to apply, you would have to have you'd still have to be married to your U.S. citizen spouse to get to apply within that 3-year period. And you would have to be living in marital union, so you couldn't be separated, because there is the marital union requirement where you're actually living with your spouse to be able to qualify for citizenship. Danevia, you are welcome. User 769, you're welcome. So as a green card holder through my dad, can I petition for my spouse? Absolutely you can. You are a green card holder and you have every right to sponsor your spouse and your children. Jhine 274, you are welcome. So I am going to head over to Instagram. This conversation does not have to end here. You can actually hop on over to Instagram with me, where you can continue asking your questions, especially if I don't get to it before I hop over. The handle on Instagram is The Immigration Attorney. So it's the same as here. Just go on over there and then hop on and we can continue like we never stop talking. Now, if you know for sure that you need a consultation, go ahead, call that number. You can call right now. It's a 24/7 phone line. Right now, after hours, receptionists are available. They'll take your information and then pass it on to the scheduling coordinator tomorrow. There's even a more convenient way to get in touch if you really don't want to pick up your phone, because I know it's late at night and you just want to relax. You can go ahead to the website and fill out a quick contact form with your name, your information, and the scheduling coordinator will get back to you on the next business day or the next day, because they are available between noon and 5 p.m. tomorrow. If not, then Monday. Thanks, Ibrahim Conte, for sharing the live. I appreciate it. So how long after you get married to a U.S. citizen can you apply for your green card? So generally speaking, there is no time. Like, they don't say you can only apply for the green card a year after getting married. There's no such rule. However, if there is something you're concerned about, you should definitely schedule a consultation first before you make any moves, because that is, that is where you're going to get the legal advice you need to move forward in a way that you avoid mistakes and you avoid severe immigration consequences. So I advise you to do that. But generally speaking, there's no time limit or on when you can actually start applying after you get married. But you need to get legal advice. The information here I'm giving you is not, it is not personal legal advice. It is general information. And so if you want to move forward, definitely want to move forward in your process, you should make sure that you schedule a consultation. So iconic, glamorous, if you cannot find it, I don't know why, I have to probably reset that button. Go ahead and go to the Instagram and just type in The Immigration Attorney. Really easy. It's the same name as here on TikTok. Can I apply for citizenship while waiting for conditional to be removed? Iconic, glamorous fashions. Yes, that is a possibility if you meet the time requirements. So for example, If you are approaching 3 years or you're on the 3-year mark, you're married, currently married to your U.S. citizen spouse, you're living in marital union in the same household, then in this case you could start the citizenship application. And what they usually do is they will process, they could schedule your interview, and they would process your I-751 application and your citizenship application all in one interview. So first they start with the I-751 interview, and if you pass that, they move on to the naturalization interview. If they don't approve the I-751 application, then they won't proceed with the citizenship. But it can be done at the same time. Thank you so much for the follow. It's been 1 year since I'm waiting for my conditional to be removed. So unfortunately, it is taking long. And iconic, glamorous fashions, this is what I do. I help clients to do exactly this. So apply to renew their 2-year to 10-year and apply for citizenship. So if you want assistance and guidance throughout the entire process, definitely call. Let's start with a consultation first. So I'm heading over to Instagram. It's The Immigration Attorney, same as here on TikTok. Join me so we can continue the conversation. If you can't join me on Instagram right now, just look for me tomorrow at 9 p.m. Eastern Time. Thanks again, everyone, for your time, for tuning in, for your questions. I'll see you tomorrow, or I'll speak to you in a consultation. Have a good one.